That I seem to have a new problem, Mr. Back, which is I don't know how I'm going to supervise you because you don't think that you did anything wrong, and this is all somebody else's fault, and you at no charge, and you are going to jail today, Mr. Back.
I'm going to jail today?
You're going to jail right now because you take no responsibility for the things that you do. Release.
With what, please? What's this?
What is Mr. Back, right?
Yes.
Represented by Mr. Moss, we have Ms. Nicholson from the prosecutor's office, Ms. Kennard from the victim's advocate's office, and we are here today for a trial, but it's my understanding that Mr. Back is going to be entering a plea of no contest to one count of domestic violence as a fourth-degree misdemeanor. Is that accurately, or I'm sorry, fourth-degree felony. Is that accurately stated?
Yes, Your Honor.
Yes.
Mr. Back, I know we've been through this once or twice before. How old are you?
55.
How far did you go in school?
I graduated high school.
Are you able to read and write English?
Yes.
Are you influenced of drugs or alcohol?
No, Your Honor.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
You're entering a plea of no contest, what I would call an open plea of no contest. That means that I have not made any representations about what I am going to sentence you to in this case. The state of Ohio has agreed that they will remain silent at sentencing and not take any position in that regard. You're going to be entering a plea of no contest to one count of domestic violence. It's a fourth-degree felony. It's punishable by up to 18 months in prison and a $2,500 fine. There is no mandatory prison in the case. There is no presumption of prison in the case. But if I do send you to prison, then the maximum penalty also includes an optional period of post-release control of up to 2 years. I don't have to do that, though. It's more likely that I would put you into my community control program. That's what most people think of as probation. That means I would give you rules to live by. If you don't follow those rules, I can change them. I can make them tougher. I could extend the time that you're on community control up to 5 years. Might include treatment in some sort of facility or some time in the local jail. Ms. Nicholson, what are the facts?
Your Honor, on June 23rd, 2025, in the city of Franklin, Warren County, Ohio, the defendant and the victim in this case, who was his kind of on-again, off-again girlfriend, there was an altercation at the residence at 620 South River Street in which the defendant knowingly caused physical harm to Heather Frisbee. The physical harm was bruising and a busted lip. There is a prior conviction from 2022 Warren County Common Pleas case, case number 22 CR 39207, in which Ms. Frisbee was the victim in that case as well.
Anything on those facts, Mr. Moss?
No, Your Honor.
It's my understanding, Mr. Back, that at least as to that recitation, that you agree that you are not going to contest those facts today, right?
Yes. Sorry.
Is this what you want to do, Mr. Back?
I mean, I'm trying to get on with my life, you know, and that's what I'm trying to do in this. You know, I just want to get this behind me and move forward. I've got a good job. You know, I'm just trying to get this behind me. That's all I'm doing. You know, and my attorneys advised me to do it, so that's what I'm doing, you know.
All right. Well, you know, Mr. Back, like I said, I went through all of your rights with you, okay? You know, I don't really like this because, you know, when you say, I want to get this behind me, that seems like that's your way of saying to me that I didn't really do anything wrong, and I just want you to put me on probation so I can follow those rules. I've been doing this for about 20 years now, Mr. Back. What I know from that is on the back end of this, you know, if I put you into my community control program, which seems likely, you're going to have a probation officer and you're going to follow some rules. You might have to do some time in the local jail. All of that every rule that you have to follow, every day that you do in jail, you're going to be angry and upset about it because in your heart of hearts, you think that you don't deserve it because you didn't do anything wrong. Those people are really difficult to supervise, Mr. Back. I'm willing to go along with that in the case because I understand that there are some risks that are associated with you being convicted of a third-degree felony rather than a fourth-degree felony. So I'm willing to go forward with this as long as you understand what all of your options are, which I think you do, right?
Yes, Your Honor.
All right. What is your plea?
No contest.
It's my understanding, well, let me ask it this way, Ms. Nicholson. What would the state's case have looked like if we would have presented it this morning?
I would have presented testimony from Heather Frisbee, Patrolman Yost, and Patrolman Crothers. And there would have been testimony from the victim who called 911. And her statement, she would have testified about what she told police and what she said happened that day. There would have been body cam footage from Patrolman Yost where Mr. Back was very clearly intoxicated, and both of them had injuries on them. They both were charged out of this incident.
And there was some physical evidence regarding pictures, right?
Yes, there were, I believe I have like 25 to 30 pictures of both of them. Miss Frisbee had multiple bruises. She had a busted lip. She had scratches and abrasions.
Should have asked this a little sooner in the process. State had the opportunity to confer with Ms. Frisbee before we went, right?
Yes, I spoke with her at length yesterday, and she was in agreement with this resolution. We
Okay.
talked about all the pros and cons, Your Honor.
Ms. Kennard, anything additional on behalf of Ms. Frisbee?
Nothing additional.
All right. Court is going to find Mr. Back guilty of this offense. I think his plea of no contest has been made in a knowing, intelligent, voluntary fashion only after he had been fully advised of his constitutional rights, which he waived and rejected here in open court. I also make an additional finding that there is substantial evidence of guilt. So I am going to find Mr. Back guilty. I'm going to order a level 2 pre-sentence investigation. So Mr. Back, you need to go back down to pretrial services today, fill out the paperwork for the PSI. Any reason not to take him off the monitor today?
The state will defer. I believe Ms. Frisbee would prefer that it remain on through sentencing. I understand there have been no issues other than the kind of Verizon outage issues that have been occurring on his monitor. There have been no violations on the monitor, and he has been on it since October, which I acknowledge is an extended period of time. But I know from my conversations with Ms. Frisbee that she would object to that.
Ms. Kennard?
She would like to make a statement in regard to that effect.
Okay.
You just take that.
If we could keep him on the monitor until he's sentenced, it would be great, because I haven't been able to. Because he used to come to my bedroom window and knock on it and stuff before, and I just don't want that to start again. With the ankle monitor, I know he hasn't even attempted to get to me, and I'd like to keep it that way.
Okay. What I'm going to do is, Mr. Back, I am going to take you off the monitor today, but I still have an order that says that you're not to have any contact whatsoever with Ms. Frisbee. And I'll tell you this, Mr. Back, if I were you and I was going to be sentenced by me in 6 weeks, I would want that monitor on, because I would not want Ms. Frisbee to come in and say, hey, he came by my house the other day. I would want evidence that establishes that is not true. But if you want to go off the monitor today, I will take you off.
Okay.
Is that what you want?
Yes, Your Honor.
All right, because if this comes before me for you engaging any of that kind of nonsense, Ms. Frisbee, get a hold of Ms. Kennard. And my history with this, Mr. Back, is the people that violate my no contacts orders between plea and sentence find themselves in jail, generally later that same day, and they find themselves on the bus to prison, usually by the time the sentencing rolls around. I have also been known to just cancel the PSI altogether when there is a violation of a no contact order between plea and sentencing. I just cancel the PSI because I don't need it.
Right. I understand. I understand clearly.
All right. State of Ohio versus James Back, 25 CR 43014. Present before the court is Mr. Back, right?
Yes.
Represented by Mr. Moss. We have Ms. Nicholson from the prosecutor's office, Officer Henry from probation, Ms. Kennard from the victim's advocate's office. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor.
We have 34 days of jail time credit, no restitutions. That sound right to everybody?
That's correct.
Yes.
All right. Ms. Nicholson, on behalf of the state.
Ms. Frisbee would like to address the court.
Okay.
Yes, Mr. Back's been in trouble, and in trouble most of his life.
Ms. Frisbee, if you could step up to a microphone, that would make it easier for us to hear you.
Hello. Mr. Beck's been in trouble in and out of most of his life, and he's had several charges against him for domestic violence. Only a few have stuck. He's done numerous times of drug and alcohol counseling. It does no good. I've inquired about a mental health facility, but apparently it's not available. But I do believe that if he was in a lockdown facility to focus on recovery and try to want to help himself, that would be the best option, because he just, he's been doing this a long time, and it doesn't seem to be helping. He doesn't seem to learn his lesson.
Are the two of you done with each other now?
Yes, completely.
Okay. All right. Anything else you want to tell me?
No, that's
All right. Thank you.
Thank you.
Ms. Nicholson, anything else?
Nothing beyond what we discussed in chambers, Your Honor.
Sir, Officer Henry?
Nothing further, Your Honor.
Mr. Moss?
Your Honor, with compliance of orders to stay away from Miss Frisbee, Mr. Back is not a danger to the community. He's demonstrated his sobriety for months now, very well, and a key indicator, I would submit to the court, a key indicator of stability and sobriety is maintaining full-time employment at a productive level. And I think that over time, I think a court's observation would be that's one of the best ways to show whether someone's going to comply with the law or not. And he's been doing that and would like to keep doing that. So I know that there was discussions of various inclinations or views of the case. I'd ask the court to consider no jail time and allow him to work, some other sanction that allows him to or at least encourages him, based on the good progress he's made, to just continue with that pattern and be productive and stay away from Miss Frisbee and stay away from alcohol. And I think alcohol is the real key. Alcohol, then the drugs. Once the alcohol starts flowing, then other stuff happens. And I think that's the key, is to stay away from that. He's shown he can do it. So that's what I'm asking the court.
Mr. Back, what do you want to tell me?
I want to just address that, Frisbee lies to the police. She's got records where she lied to them about their social security number and name and went to jail for it. I want to address that Frisbee's not, I had to apologize to my friends of bringing her over there because she drugged them. She's making drinks and put drugs in their alcohol. And how I know this is to be true is she was hanging out with 3 of her other girlfriends, and none of them do Xanax. Well, this girl's been going to the pain clinic for 12 years, never ever failed a drug test until Frisbee put some Xanaxes in her drink. And she's got a pattern, like she put her own father in prison, made statements on what her own father, her father was up there at some restaurant, he'd seen her and had to leave. She likes to, because I wanted to break it up with her for like 3 months. She was talking about knocking on her window, and she just walked right in my house. I was like, Heather, don't be walking in my house. And she just smiled at me, look at me sideways. She's just dangerous. She's a lying, dangerous person, that's all. And she'll pay for this in this lifetime and the next, I believe, from God. From God himself. It's just upsetting because I know I'm innocent. And I'm thinking about it.
Oh, I gotta say, Mr. Back, this was not the way that I expected this hearing to go today. Yeah. Okay. Here's where we're at. Mr. Back, you pled no contest. I found you guilty. Going back to, let's see, July of 2022, you entered an Alford plea, which says I'm pleading guilty and I didn't do anything wrong, but I'm pleading guilty anyway. That's what happened with the last time that you were here. And it occurs to me I seem to have a new problem, Mr. Back, which is I don't know how I'm going to supervise you because you don't think that you did anything wrong, and this is all somebody else's fault. And I mean, I've been doing this long enough to know that it's probably a little bit not all your fault, but you got to start taking responsibility for your part in this, and you are not. So here's what I'm going to do. I'm going to put you into my community control program for a period of 3 years. I'm going to order that you serve 60 days in the county jail. I'm going to credit you the 34 days that you have already done. The PSI says 5, but we had an old case, so it actually should be 34. So you still have 26 days left to do. You're going to enter into and successfully complete the Batterers Intervention Program, and you're going to do drug and alcohol counseling. 3 ingredients to this problem that we have. It is you, it is Ms. Frisbee, and it is drug and alcohol. When I put those 3 things together, I get an offense of domestic violence. So I'm going to eliminate 2 of those 3 things from your life. I'm going to eliminate drugs and alcohol, and I'm going to eliminate Ms. Frisbee, because there's also a term of your community control that you are not to have any contact with Ms. Frisbee. I don't care if she wants to have contact with you. That doesn't matter to me. If you have contact with her, then it's a violation of the terms of your supervision. I'm not going to impose a fine. I am going to impose the costs upon you. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 36 months in prison, plus an optional period of post-release control of up to 2 years. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, then that will be provided to you at no charge, and you are going to jail today, Mr. Back.
Going to jail today?
You're going to jail right now because you take no responsibility for the things that you do.
Your Honor, is that jail with or without work release?
With work release.
With what, please? What's this? Okay. You gotta call your boss. Go there.
Like Frank. We'll get the stuff out.
You gotta like your friend.
This way, sir.
Do you have anything you want to?